You're listening to the Smart Policy Podcast, a production of the University of Tennessee's Institute for Public Service. Earlier this year, 3 different bills were filed that would all increase the penalty for possessing fentanyl to a Class B felony. One would accomplish this by reclassifying fentanyl as an agent of chemical warfare. Although this bill was returned to the clerk's desk as 2 complementary pieces of legislation advanced. Those bills, Senate Bill 193 and 1398, the latter of which is known simply as the One Pill Will Kill Act, make a pretty straightforward change. They increase the penalty to a Class B felony without redefining fentanyl. These bills were signed by Governor Lee on May 11th. And for some quick drug policy trivia, this was the same day that he signed the cannabinoid regulation bill, as well as the legislation adding the second wave of opioid settlements to the OAC Trust Fund. In any case, when these bills were passing through the legislature, we at SMART heard a lot of concerns about making fentanyl possession a felony. Specifically, advocates wanted to know if this would lead to more Tennesseans winding up in prison with a lifelong felony charge on their record, just because they had a single pill. So my guest this month is Circuit Court Judge Dwayne Sloan. A strong advocate of drug recovery court and increasing access to medical treatment for addiction, we figured he would be able to give us a good insight into how these bills will impact the lives of Tennesseans.
I'm Dwayne Sloan, Circuit Court Judge for the 4th Judicial District, State of Tennessee.
All right, thank you for joining me.
Thank you for having me.
This last legislative session here in Tennessee, a couple of bills passed. One is titled the One Pill Will Kill Act, and the other one is very similar, just affects the Tennessee Code in another place. But they effectively do largely the same thing in that they add a felony penalty to possession of fentanyl or any of its analogs at a threshold of 0.5 grams or more. And just wanted to make sure we fully understood what was going on with this.
Yeah, so the actually what the legislation has done was to classify the fentanyl analogs as a Class B felony, which really all that does is put it in line with, for example, cocaine. So that's really the effect of the legislation. And it's not just a possession of 0.5 grams or more. You still have to have the possess it with the intent to sell it.
Oh, really? Oh, okay. In my cursory review of it, it looked like just simple possession might land somebody with a felony.
No. It's just it's 0.5 grams or more but you still have to have the intention to sell or deliver it,
okay,
or be manufacturing it.
Right. And I understand One Pill Will Kill also gets into some specifications with whether or not a deadly weapon is involved in some commission of a crime.
Yeah, if you have a weapon in the commission of a felony, that's been the law for some time anyway.
Right. So it does sound like a lot of this is just crossing T's and dotting I's. Like it's really not that much of a fundamental overhaul.
Not at all.
Okay.
Not at all. It really just gets the fentanyl analogs kind of in line with the dangerousness of and no medical purpose of, or like, again, using the example of cocaine. Of course, now we all know that fentanyl is used for treatment of pain in, say, a hospital setting. But really, this is getting at the different fentanyl analogs that are so dangerous and that are so potent and killing people.
Right. So Schedule I drugs are those with no currently accepted medical use with a high potential for abuse. So this currently includes heroin, LSD, and, for example, marijuana is still Schedule I, even though now more than half of our states have legalized it to some degree. Schedule II drugs also have a high potential of abuse, but there are some limited medical uses. And so fentanyl is currently Schedule II. You've also got Adderall, oxycodone, Dilaudid, methadone, cocaine, so on and so forth. And then there's Schedule 3, and then there's Schedule 4 and Schedule 5, and so on and so forth. So this bill is obviously, it's a state level. It's not affecting scheduling. That's a federal level policy. This is affecting how the state of Tennessee prosecutes possession of certain drugs. So the purpose of this bill then would to take the analogs, the synthesized one, these new ones that weren't created by pharmaceutical companies, and treat those pretty much exactly like cocaine and heroin, as you said. Is this likely to have a significant difference in sentencing outcomes when it comes to people prosecuted for drug crimes?
I don't see it really making a major difference as far as the sentences people that are receiving for the possession with the intent to sell or selling or delivering the fentanyl analogs.
Okay. Well,
and you hit on something about the half the states legalizing marijuana. I find it really interesting when people say that, because the state cannot legalize it; they can decriminalize it. Because it's still a violation of federal law.
Right. So yeah, we did see in the fiscal bill, or the fiscal note for both of these bills, that there is an increase of state expenditures, but it's not an astronomical amount. It's not the amount you would anticipate if there were suddenly a lot of felony prosecutions. And again, I know we're speaking very specifically of this legislation, but this really is a situation where we're just clarifying in the law that fentanyl and its analogs should be treated like dealing cocaine or methamphetamine and some of the other drugs we've come to associate with hazardous outcomes.
That's correct. And I'm actually pulling up the summary of the legislation right now. Here's the summary. It increases the penalty. This would be Senate Bill 193, House Bill 702. Increases the penalty to a Class B felony with a fine up to $100,000 for drug offenses involving 0.5 grams or more fentanyl, carfentanil, remifentanil, alfentanil, thiofentanil, or any fentanyl derivative or analog. That removes the reference to fentanyl derivatives and analogs and names the act the One Pill Will Kill Act. I mean, so again, it's you still have to prove the intention to the intention to distribute it or manufacture it.
This is very helpful and very promising, because I've been hearing a lot of concerns from nonprofits and whatnot that this might lead to over-incarceration all over again, more reliance on prisons, more felony charges, and that this would criminalize to a pretty severe extent simple possession. One single pill. To the average person, that doesn't sound like intent to sell, but you're saying that you would have to show other evidence of intent to sell to actually get that felony.
Yeah, again, it's simple possession is still going to be simple possession. I mean, you're talking about a consumer. Now when you're looking at whether somebody is possessing and they have the intent to sell or deliver it, then you look at the circumstances around what was going on, right? I mean, so if you possess a certain amount of fentanyl and you also have scales, which that could be an indicator that you have the intent to distribute it, then there's usually other things like call logs, little book with showing the transactions and how much was sold for, different baggies around, different things like that you're looking at to determine the what the state of mind, the intention was. But but regardless, I mean, for example, someone could have 5 or 6 grams of it and still not have the intention to sell or deliver it. But once you start moving up in weight, then the weight in and of itself can be enough to prove that someone had the intention to sell or deliver.
And that's a very good point. You said 5 or 6 grams. That is actually an enormous amount of fentanyl. If it's just pure fentanyl we're talking about, being just such small amounts are a dose, as it were, for lack of a better term. That is a concern I did hear from someone, that the way it's written, that 0.5 grams. And that would be the total weight. So the pill would, whatever emulsifying, whatever extra substance is in that pill is also factored into that 0.5 grams. It's not 0.5 grams of the pure fentanyl, which also would be a considerable amount. It's 0.5 grams of the entire substance. I had heard a concern that the way it's written, it might put in, say, a jury's mind that 0.5 grams is in and of itself one of those extreme amounts that can be evidence alone of intent to sell.
No, no, no. That's and of course the state would have to argue that theory. However, that's pretty easy to overcome by way of a defense if you just are possessing that small of a weight with no other indication of an intention to distribute it. I can't imagine a jury finding somebody guilty just because they possess that much. And a judge, if it actually went to a jury trial, a judge always has the obligation to set a jury verdict aside if the sitting as 13th juror, if you will, to not affirm that jury verdict.
Okay. Well, that's really good to know. Texas, Oklahoma, South Dakota, there have been a number of states that have been prosecuting individuals who haven't, what we say in the minds of the common person, might not meet the definition of a drug dealer. Say, for example, there was a case in Tennessee recently, 3 teenage girls, 2 of them died, 1 of them did not, and now she's being charged with second-degree murder because she did purchase the substance and distribute it to her friends, but it wasn't so much. I think a lot of people might think, well, she's not really a drug dealer; she's just so much a user that's sharing. And this does seem to be part of that broader trend. I was wondering if you might be able to reflect on that.
Yeah, for sure. Now, that's is different, of course, than what we're talking about with the new legislation. Right. But yes, if you knowingly distribute, which means even deliver, even share with a friend something that you've purchased, and that because this is such a lethal substance, right, that you knowingly deliver that, even sharing it with a friend, and the person dies, yes, you can be charged and convicted of second-degree murder. Now, in the 4th Judicial District and in my courts, there have been a few people charged with second-degree murder, but those were negotiated down to something much less because of the surrounding circumstances.
Is this likely to impact drug courts at all? I know drug courts don't take every case. It depends on the extent of involved crimes, things like that. But is this likely to have any impact therein?
I don't think so. Because the increased exposure, it might give us more of an opportunity to be able to serve people through drug recovery courts than before. But really, I don't anticipate any noticeable difference.
Okay, interesting. By expanding capacity, what do you mean?
Well, expanding our not our capacity to serve, but the number of people that come into drug recovery court as a part of their plea negotiations, et cetera. Because of their increased exposure, they might be more motivated to pursue drug recovery court as opposed to taking their chances of going to just serving jail time or going to prison. So maybe more leverage even for the district attorney to use to motivate someone to actually apply to drug recovery court. And I can't see any drug recovery court excluding somebody because it was fentanyl. I mean, there was the people we want to help, and typically the people you see prosecuted in state courts for selling, delivering drugs, they're typically people that are supporting their own use. Now there are people that are making money or making some more money than what it takes to support their own use, but what we think of big time drug dealers, they're not prosecuted in state court anymore and haven't been for a long time. They're prosecuted in federal court.
Right. And that makes absolute sense, especially with increasing relation to cartels, which is just an enormous network. That makes quite a lot of sense and is a very interesting point. So a situation, someone is caught, they're looking at a felony charge, they think they might want to try to fight it. No, there's no way I was trying to sell this. That is a conversation that opens up. It's like, look, you can just go to drug court and we can work with you here, and whatever the situation of the case may be, you might be able to avoid jail time or have significantly reduced jail time, so on and so forth.
Well, exactly. That's exactly right. And it's the way it always kind of is. I mean, do you take your chance and try the case to a jury? The jury then convicts you, and then you end up in prison, or do you take advantage of this opportunity to get help? And our district attorney, they all, I think, in this state, no, for sure in the 4th Judicial District, I mean, you really are looking to determine what that person's true intention was, and make sure that the charge and ultimately the disposition, matches up with the reality of what is actually going on.
Right. And not to mention, if they decide to really fight it, that they might incur some serious legal bills too.
But most of them are actually, represented by the public defender's office.
Right.
But yes, I guess some of them actually do. Some of them actually do hire private counsel, but it's the vast majority of the people prosecuted for drug trafficking in Tennessee are going to be represented by the public defender's office.
That makes quite a lot of sense. Well, this is very enlightening because, as I said, I'd heard from several different people that they were concerned about how this might be 1992 all over again, but it really doesn't seem that way.
Not at all. Not at all. No, it really just, in my opinion, it gets the fentanyl analogs in alignment, again, using cocaine for an example, and that's where it should be.
So I do understand there's a decades-old law. I think it was passed under Reagan, but this was when novel psychoactive substances first started coming around, and the intention of this law was to provide a legal scaffolding to prosecute for chemicals that are substantially similar, I think is literally the phrase the law uses, to known drugs. But being that these laboratories are cranking out hundreds, if not thousands, of analogs and just slight tweaks and differences, it allows the courts to stay ahead of the chemists in this way. And this law is still being used today to go after dealers. Does this just simply add more clarity? It just makes it a little bit easier. And and of course that's a federal law, and these would be state laws.
Well, that's still a good point that you made about what the intention of that federal legislation was and what this legislation is doing, because to a point you just made is the analogs are constantly changing, just a small tweak. So it allows us to stay ahead of that.
It got me thinking, because back in 2017, under the Trump administration, fentanyl and its analogs were temporarily made Schedule 1. Previously, of course, fentanyl was Schedule 2, but now fentanyl and its analogs are all Schedule 1. There have been a couple of bills this year, one Democrat-sponsored in the Senate. Now, that's the Temporary Emergency Scheduling and Testing, or TEST, of Fentanyl Analogs Act, which extends the temporary class-wide scheduling of fentanyl and its analogs for 2 more years, that temporary Schedule 1. And it would require the DOJ to conduct scientific and medical evaluation of these substances to encourage research, and that we can study and develop treatments for fentanyl-related substances. The sponsor, Cory Booker, has actually come out against class-wide scheduling of fentanyl and its analogs. And he points to the rising overdose deaths that have continued even after 2017. But then in the House, a Republican-sponsored bill called the Halt All Lethal Trafficking, or HALT, Fentanyl Act, which passed with bipartisan support, would permanently extend the Schedule 1 status to fentanyl and all of its analogs. Is that a direction you think that might be beneficial in general? To just say, hey, let's go ahead and make this Schedule 1 and keep it that way, because it's clearly killing people.
Well, I sure don't have a problem with moving the fentanyl analogs. Anything that doesn't have a medical purpose, and especially the drugs that have the lethality potential that these fentanyl analogs do. I have no problem with that whatsoever.
That makes sense. I mean, 1,000 times stronger than morphine, things like that. Yeah, just
this one of the latest is. Well, I know that carfentanil was 10,000 times stronger, but I've heard of something being 50,000 times stronger. But that might be, I might be confusing that with xylazine.
Well, there's nitazines. I think you might be thinking of, and xylazine is certainly a disturbing adulterant that extends the high of fentanyl, for example, even though it's an animal drug. I like how you clarified too, though, that we're talking about these analogs, these novel substances that are different than old school pharmaceutical fentanyl, which was first created, like 70 years ago by Janssen, is used in surgeries. That's just a different situation here than what's being synthesized in labs, and no one knows what's in it.
Absolutely. And you made a point earlier about, a lot of people really don't know that fentanyl is in the product, but, because I try to help a lot of people that are in recovery and, drug trafficking prosecution officers, but a lot of people really are chasing fentanyl, and they know a lot of them know it's not heroin. They know it's a fentanyl analog, but they go after it, even knowing how lethal it is because of its potency.
Right. That makes a lot of sense. We've heard from Dr. Lloyd has talked about this, about how high his daily dose got, and how he was just so before he had gone into recovery himself all those years ago. Everyday struggle was just trying to maintain that daily dose because the tolerance was so high he wouldn't go dope sick. And this even ties back into xylazine. I've heard that because fentanyl has such a quick half-life in the body, that it's only a few hours before you start going into withdrawals, even though it's so potent. So that's why people are getting xylazine. But of course, that doesn't really address the underlying issue. And so they wake up from that high and they're already in withdrawals and so on and so forth.
Right.
But yeah, that is an important point too, that yes, there's definitely quite a few people unknowingly taking it, but the very act of seeking it out just to maintain that.
Yeah, for sure. And I've been doing this work for a long time, and I've never seen it this bad out on the streets. The number locally of our overdose deaths have just continued to increase. It is really bad out there. I mean, it's people just need to know that you can't assume that fentanyl is not in anything you buy. Cocaine, methamphetamine, heroin, even we've heard stories about marijuana containing it because it's being added to increase the potency and the high.
I've heard it said if it doesn't come from a pharmacist in a bottle, then you just really don't know. What are your thoughts on recent efforts to improve access to consumer end testing? The fentanyl test strips, and now there's plans to get xylazine test strips out there.
Well, I'm very much for increased access for the test strips. However, I do understand the logic of people that are opposed to it because it might give you a false sense of security in consuming, especially if it's not accurate, if the read's not accurate. But I mean, at the end of the day, though, I fall on the side of increasing access to test strips. I think we're going to save more lives that way than we lose.
I agree completely. Are there any final thoughts?
No, but I'm sure enjoyed the conversation. Hope it is beneficial.
Thank you so much, Judge. I really appreciate it.
All right. Always good to see you, brother. Take care. Have a good day.
You too.
Bye.
For more episodes on in-depth discussions on Tennessee policies related to substance use disorder by a range of local experts, please subscribe to us wherever you get podcasts and visit our website at smart.tennessee.edu. I'm Jeremy Corvellis. Thank you for listening, and see you next month.